They say a judge should be judged not from the linchpin of impartiality, but whether he or she had a prejudice to do good. Someone who has been part of numerous historic judgments, both as Supreme Court judge and also as the Chief Justice of India, is the newly retired ex-Chief Justice of India, DY Chandrachud. Thank you very much for joining us here on CNN News 18. My colleague Ananya Bhatnagar is also joining us in this interview. I said you were part of numerous historic judgments, from the Ayodhya Ram Mandir judgment, the 370 judgment, the electoral bonds judgment. When you look back at your tenure as 6 years, first as Supreme Court judge and then subsequently 2 years as Chief Justice, what according to you was the highlight, the thing that you enjoyed the most, and is there one thing that you would have done differently in these last 8 years?
Well, the difference between being a lawyer, which I was for 18 years, and being a judge is that a lawyer is tied down to a brief. You have to succeed for a client. A judge has no client. You have no pressure to succeed for a particular party as a lawyer has to do. For a judge, you have to decide what is right. And I think that is the key difference from a life in the law as a lawyer and a life as a judge. When it comes to being a judge of the Supreme Court, which I was for 8.5 years, including 2 years as Chief Justice of India, there's a further degree of liberation in the sense that in the High Courts we are bound by what the Supreme Court says to be the law on the subject. As a judge of the Supreme Court, you are comparatively liberated from the discipline of having to obey a higher court. Of course, we are also bound by our own judgments, but with the feeling that you can correct a judgment which you believe is not attuned to the times or which is not correct, to lay down a more just outcome. And that, I think, in the Supreme Court as a judge is the key difference. I was Chief Justice of the Allahabad High Court for well over 2 years, in fact, 27 months. And I think the major difference that occurs when you become a judge of the Supreme Court is that judging is your universe. As Chief Justices, you have to do a lot of administrative work of the state judiciary. As a judge of the Supreme Court, you're primarily, if not exclusively, doing judicial work. But when it comes to being a Chief Justice of India, the Chief Justice of India is first and foremost a judge like every other judge. In fact, they say that the Chief Justice of India is the first amongst equals. So you are judged like every other judge. But having said that, there are duties, there are obligations of the Chief Justice which are incomparable in the sense of the fact that you are overseeing the affairs of the Indian judiciary. There are 18,000 courts in India, spread over 3,000 establishments across the length and breadth of the country. You're looking after appointments, you're looking after infrastructural issues, budgeting, finance. So your work on the administrative side as Chief Justice of India really begins after the day's work as a judge comes to an end at 4 o'clock in the evening.
I do want to ask you, one of the issues, it preceded you, and I guess it is there, beyond your time as well, is the pendency of cases. And I believe when you took over as Chief Justice of India, the Supreme Court had 92,000 pending cases. It's been reduced to about 82,000 is what I'm told. Whereas in the other courts, high courts, lower courts, there's still more than 5 crore cases that are pending. What did you do to move the needle on this issue of pendency, because this directly affects the common man, the long wait time to get justice?
Well, looking at the pendency, there's a flip side as well, which is that the pendency itself is reflective of the fact that people have faith in the institution. You look at a lot of authoritarian regimes in certain parts of the world and you'll find that they're extraordinarily efficient because the inflow of cases is then tightly controlled. Even in democratic societies, say like the United States or some of the other Western nations, you will not have the kind of pendency which we have, for the reason that we have an open access to justice model. And we do not shun cases of even small citizens, small issues relating to citizens, merely because they are small cases. They travel all the way up to the Supreme Court. What we've done to address the issue of pendency, as you rightly said, there are about 92 or 93,000 cases when I took over, and that has been brought down to 82,000. Now, the first thing which we did was transparency. Before I took over, the unregistered cases were never recorded in the system. And I said, that's not proper. We have to record every case that comes into the system. Because the first step for management of litigation is knowledge management and information management. Having done that, what we did was that we introduced a new system of case categorization, which was about 2 decades old in the Supreme Court. We have a completely modern case categorization in the Supreme Court. Now that helped us to identify bunches of cases. For instance, if there are 1,500 cases under the land acquisition law raising the same issue, they could be bunched together and allocated to one bench. If there are cases on the same point in the income tax law, they could be assigned to one bench on the income tax law, so on and so forth. So the first thing that we therefore did was to ensure that we classified cases. Having classified these cases, to have a very scientific methodology of assigning these cases to courts. The third thing that we did was, and which I've tried to do during my tenure, is to have an assignment of cases which follows domain specialization. Otherwise, there was in the Supreme Court a tendency to allocate everything to everyone. Everyone is not necessarily well versed in the same branches of law. And it's important that we specialize more significantly. So these were some of the steps which we took for the purpose of identifying cases, allocation of cases, and as the head of the judiciary, to keep a watch on what the results are. Have we been able to succeed? Because you have to constantly modulate your strategy. Now, to just give you one example, when I took over as Chief Justice of India, there were 28,000 cases which were what we call the regular hearing cases. These are cases which have been admitted to hearing. Some of these may have been a decade or 2 decades old. The pendency of the regular hearing cases has been brought down from 28,000 to 22,000. During the same period that we are talking about, and actually a little longer, in 2020, about 29,000 cases were filed in the Supreme Court. This year, 2024, we are anticipating that the figure will go up to 60,000 cases. So, though there has been a doubling of the cases filed in the Supreme Court, you still find that there has been a reduction in the arrears. So, the reduction of arrears is not just the 10,000 cases which now stand reduced from the statistical backlog of the court, but taking into account the fact that the filing of new cases has more than doubled in the Supreme Court. And that's going to be a trend which is going to take place in future as well.
There is a growing trend where we see that a particular judge's religion or sect is basically taken as him being a little biased towards it, or his judgments are pretty biased. People criticize them on this aspect. How do you see this? And there is a general notion that if a judge is atheist, he's in fact who's somebody who's impartial. Do you agree with this, or how do you see this concept?
Well, I've said this before, that a judge to be impartial does not have to be an atheist. All of us judges are citizens, and as citizens we are entitled to the same fundamental rights that every other citizen has. And judges are humans. In fact, the fact that we are human beings ensures that we understand the problems of other human beings. Now, having said that, and answering your question particularly in the context of religion, the Constitution gives to each one of us as citizens the right to freely profess and propagate our religion and the freedom of conscience. And judges as citizens, as human beings governed by the rule of law and the rule of the Constitution in India, are entitled to exactly the same freedoms. Now, having said that, it's important to understand that the individual beliefs of judges in terms of their own faith has nothing to do with how they decide cases, because by training we are expected, and we do decide cases in accordance with the law and in accordance with the Constitution. For that matter, why do we only confine ourselves to religion? Can we, for instance, say that it's only a woman judge who can understand or do justice to a case involving women? Obviously not. Can we say that, well, a judge having only a particular background in terms of, say, sexuality can do justice to that particular category of cases bearing on sexuality? Obviously not. So judges by their very training are, we are taught to be, and we are expected to be diverse in our approach. Now, therefore, you look at this issue not just from the doctrinal perspective, as I told you a short while ago, but also from the perspective of what the statistics tell you. You will find that it's judges drawn from across the diversity of faiths, of cultural backgrounds, of regional backgrounds, of linguistic backgrounds, who do justice across the spectrum. In fact, if this argument were to be taken that it's only a judge who does not profess a religious background who can be truly impartial, but that would apply across the board to region, to culture, to language, to gender. And that's not, therefore, the case, as we know.
But just I think two specific instances where you had personally sort of drawn flack for was one when you revealed that you had sort of prayed before you delivered the Ayodhya judgment, and more recently in this house, the Aarti that was performed with the Prime Minister. Those two specific instances, how would you respond?
Well, I've spoken about it earlier. Insofar as the first, merely because I prayed before a particular judgment does not mean that I prayed only before that judgment. I've made it very obvious and clear that, well, I'm a person of faith and I do pray every single day. And I don't believe that I have to be hypocritical enough to conceal the fact that I'm a man of faith. And I believe that my faith has nothing to do with my ability to dispense justice. The other thing, I said a short while ago that we decide in accordance with the Constitution and the law. But having said that, it's equally important for judges to have a sense of equanimity, because all the work which we do is in arenas of conflict. People who come to court are involved in conflicts. Conflicts between husband and wife, conflict between states and the union, conflicts over, say, the sharing of river waters between two states, conflict between a corporate interest and a private body, so on and so forth. So across the spectrum. Now, what is it that keeps a judge rooted to ensure that you maintain that sense of calm in the way you conduct your proceedings, in the sense in which you hear citizens' problems, that you don't make short shrift, that you don't get irritable in the court, that you do not get drawn into the vortex of conflict before you. Everybody has his own formula, everybody has his own problem, or they have their own methodology of dealing with the areas of conflict that they have to deal with. For me, the time that I spend in meditation, in quietude at the beginning of every day, is what I believe is crucial to maintain that sense of equanimity. Having said that, and let me make it very clear, that I didn't say that I pray to a particular deity. I said that I spend my time in prayer, in meditation, in the invocation of God. And in that sense, I believe that the God to which I pray, the God to whom I invoke some sense of calm and equanimity in my work, is universal. So praying to God does not mean that you are praying to a particular religion or to a particular deity, but to that sense in the universe which defines our existence, that let the work which we do today be not the cause of injustice to any citizen. So if it is understood in that perspective, I don't believe that there is anything wrong at all. And far from concealing that we are all people who are committed to doing justice within the framework of law, albeit in the context of our own faiths, I think that underlies what the true essence of judging is, and not just in India but across the world.
Well, what about the second instance? There it was a representation of faith and also the proximity to the executive, whom you are supposed to keep a check on.
Well, on the second aspect that you mentioned, it's important to understand that there is obviously this has not been today. This has been since the dawn of independence in 1950, and it's documented. There are dialogues between the executive and the judiciary. I've said that there is a dialogue between the chief ministers and the chief justices in the high courts. Now, you may be meeting for a particular issue pertaining to the infrastructure of the high court, or you may be meeting on a social occasion. The important thing is that our system does have the sense of political maturity, that this sense of dialogue, of conversation, does not impinge on the judicial work which we do. Let me explain this further. As the head of the judiciary, the Chief Justice of India has to ensure that recommendations which are made for appointment of judges, that these recommendations are duly carried through by the government. Now, obviously, one way of doing it would be just to write letters. The other is to engage in a robust dialogue. And I therefore have to meet the law minister. And I did meet the law minister very frequently to ensure that pending proposals were cleared. Now, we met each other in the confidence of my own residence, because the law minister normally would always comes to the Chief Justice of India to discuss a pending issue which needs attention. Now, therefore, the sense of dialogue per se is not contrary to judicial independence. The sense of robust dialogue between the executive and the judiciary is necessary to ensure that the affairs of state, the affairs of governance, are duly carried on with a sense of efficiency. On the particular example which you gave me and the point that you made about the Prime Minister visiting my house, Prime Ministers are known to visit homes of judges on various occasions, social occasions, maybe happy occasions, sometimes difficult occasions, as for instance when there's a bereavement, or likewise in the Chief Ministers visiting the house of the Chief Justice of the High Court. Nobody for that matter would even in their remotest dreams postulate that merely because there was a visit to the house of a judge or a Chief Justice that this impinged on their ability to do justice in the court. Ultimately, judges are evaluated by their written word, and that's the test. Can you pinpoint even a single instance where the outcome of the case has been deflected because of the fact that there was a dialogue between the judiciary and the executive? And obviously, no. Both before and after that visit, I do believe that no one will have even a single case which I have decided where it could be even remotely suggested that that visit affected the outcome of a case. You may criticize my view in a given case as being correct or wrong, because there are obviously two views about any case that we decide. That's why cases come to the Supreme Court. They travel up the system because there's obviously a difference of opinion, and in important cases there could be two views about it, and people are entitled to either agree or disagree. But to impute motives to the judges is something which I have very serious reservations about.
But एक टाइम पे जब हम we talk about the collegium system, the thing which we appoint judges at this particular point from the law of the land, बहुत सारे लोगों का ये कहना है कि either it needs a rework, it's a bit slow one, and there are a lot of times when the government stops certain names are not brought up. So how do you see this? Does the collegium actually needs a rework, या कुछ बदलाव की जरूरत है collegium system के अंदर फिलहाल?
देखिए, आप किसी भी प्रणाली को देखें तो आप ये नहीं कह सकते कि किसी प्रणाली में कमियां नहीं हैं. In a democracy, you can't say that every institution is perfect. But merely because the institution is not perfect is not a reason for discarding that institution. उसमें कमियां हैं, इसके मायने आप ये नहीं कह सकते कि इसको जड़ से आप उखाड़ दो. उसमें कमियां हैं तो उसको सुधारने की ज़रूरत है. We did a lot of things in the recent past to ensure that some of the perceived deficiencies of the collegium were answered. For instance, we have put out into the public realm the resolutions of the collegium. We have put out into the public realm the parameters which we apply to taking decisions on who should be appointed to the Supreme Court. So we have put out upfront on the website of the Supreme Court what are the parameters that we apply in selecting judges for appointment. And now we have to be very conscious of the fact that when we either select or do not select judges for appointment, particularly to the Supreme Court, you are dealing with the careers and lives of judges in the Indian judiciary. Judges who have spent years in the high courts. There is an element of their privacy involved as well, their dignity as well. If a judge who is under consideration for appointment to the Supreme Court from the High Court is not appointed to the Supreme Court, they still continue in their careers as judges of the High Courts. So, while making a disclosure of reasons, you have to be careful of the fact that you don't throw the baby out of the bathwater, because their dignity, their ability to continue, their ability to render justice should not be diluted or affected. We've taken other steps as well in the process of ensuring that the appointments which are made do fulfill objective parameters. And we, for instance, we now operate in a paperless environment. We circulate judgments of the judges who are under consideration for appointment to the Supreme Court, say typically the first 50 judges. We collate their judgments. We circulate this data to the judges in the collegium. Each of us studies those judgments. We are incidentally also looking at the judgments of those people who are under consideration when we deal with cases on a day-to-day basis. But then we look at cases which have been decided at the same time. The same judgments will be then circulated to all the judges in the collegium. So through all these means, we have been trying to ensure a greater degree of impartiality and objectivity to the appointment process.
Taking this a little further, we have seen that the Supreme Court was dealing with a case pertaining to the delay in the appointments that had happened. Do you think that an intervention on the judicial side with regards to the executive clearing or non-clearing those names is something that is warranted or something that needs to be done?
First and foremost, let's look at the statistics. During my tenure of 2 years in the Supreme Court, 18 appointments were made to the Supreme Court. All the 18 appointments which we had recommended have been made. 40 out of 42 appointments which were recommended for the high courts have been made as Chief Justices. Apart from that, about 127 appointments out of the 164 recommended to the high courts have been made to the high court judges. So if you look at the broad gamut of appointments, the large number of appointments have been made. Now, we have to understand that there are diverse stakeholders in the appointment process. You have the collegiums in the high courts. You have the state governments because we are a federal country. We have the Supreme Court because we have a very vital role to play in terms of the judgments in the judge's case. And you have the union government because the ultimate appointments are made by the President of India. Now, we are a federal country. It's a complex country. And therefore, the very process of appointments is not as simple as it would be in, a unitary sort of political system. Now, the reason why I have very strong reservations about taking the issue of appointments on the judicial side is because we are one stakeholder in the system. The Supreme Court is one stakeholder in the process of appointment, albeit an important stakeholder. Now, if we use our judicial power to ensure that persons whom we recommend are appointed, we'd be then using the judicial power to implement essentially what are our constitutional recommendations by the collegium, which I have reservations about. My answer is that there has to be a sense of robust dialogue between the government and the judiciary. If the government has certain reservations on the appointment which has been suggested by the judiciary, we must understand what those reservations are. Sometimes those reservations may be quite justified. At other times, they may not be justified. So we had examples on both ends of the spectrum. Where we have found that those reservations are not justified, we have reiterated those recommendations. Equally, it's important to understand that in the collegium system, it's not just the government which has a veto. The judiciary as well has a veto. A judge whom the collegium does not find fit for appointment to the judiciary can never become a judge. So it shows that there are weights and there are checks and balances. Yes, there have been times when I have felt that certain appointments should not be held up, and I've been in continuous dialogue with the government to ensure that those appointments should be made. And I'd be happy if those appointments are made at the earliest.
Chief Justice, before you became Chief Justice, maybe because of some of the judgments that you were part of, whether it was privacy as a fundamental right, decriminalizing homosexuality, you were painted out to be this liberal poster boy. But after your tenure as CJI, the very same liberals who painted that image of you are disappointed that you haven't been an adequate check on the executive, that your judgments have not necessarily kept those in power in check. How would you respond to that criticism?
Well, I don't subscribe to the label of being either a liberal or a conservative for the reason that postulates that the judiciary itself is a political organ of the state, which I don't subscribe to. When people call a judge liberal or they call a judge conservative, that postulates that they are ideologically liberal or ideologically conservative. And that has a political assumption underlying that statement, which I do not subscribe to. Judges have to look at and do look at cases on a case-by-case basis and then decide which side of the line the balance of justice lies. Now, Another concern which I have is this, that today in a largely polarized polity, a judge is regarded as independent by one segment of the polity if you hold in favor of the view which that particular body of opinion subscribes to. If you accept that view as the correct view, then the judge is treated to be independent. If the judge accepts a view which is contrary to that particular view, they are regarded as not being independent. Independence is not a function of whether you decide in favor of what you call the left or the right or whichever side of the polity, but a decision which is in accordance with the Constitution and the law. And that, to my mind, is very crucial, because today, increasingly, you see that the social media is being used by a variety of pressure groups and interest groups. Even before a case comes into the court, social media is abuzz, and these pressure groups are abuzz with what is going to be argued in the court. Even before we hear an argument, we are told what the argument is going to be. So various forms of communication and the electronic forms of communication are being used today to, in that sense, influence judges. Now, by training, judges should not be falling a prey to these kind of attacks on the system, which I feel is very important to preserve the independence of the
But they're using this to sort of broad brush even your record or your legacy. I will quote to you one liberal academic who's written in a newspaper looking at your legacy, your tenure as CJI. The scorecard approach with relation to Justice Chandrachud does not work. He was more artful than that. Like the Prime Minister, could throw a dollop of paint on a building while letting its foundations rot with judicial termite to keep the veneer and form alive that we might get justice from the Chief Justice. He was a judge for the age of Modi because he personified the style of this age, an age that converts civil and political rights into an act of personal beneficence. When people argue that you're a great defender of personal freedoms and civil liberties, but you've not applied that to every case that's come before you or every case that's come before the Supreme Court. How do you respond to that?
Well, first and foremost, I think it's important to understand that a judge is entitled to decide each individual case in accordance with the perception of the law and of the facts which that judge bears. Now, what my objection really is this, that when we decide, say, the electoral bonds case, and we strike down the electoral bond scheme, well, the Supreme Court is heralded as being an independent institution. When we delivered the judgment in the Aligarh Muslim University case, well, we are said to be an independent court. But when we take a decision which does not favor this particular body of opinion, then we are criticized as not being independent. That is my concern. To expect that you must at all instances and in all circumstances follow a body of political opinion on one side of the spectrum is not my definition of independence. And moreover, it would be wrong to expect that the Supreme Court of India should perform the role of a political opposition. We are not a political opposition in Parliament. We are there to scrutinize executive actions on the touchstone of law, irrespective of whether the outcome of that scrutiny is either in favor of the government or against the government. And it would be really in that sense far-fetched to look at individual cases and say, well, this case went on this side and the other case went on the other side of the spectrum. You would find in the career of every judge cases which have gone on both sides of the spectrum. How does that affect the independence of the judiciary? But this is exactly the point of people on one side of the spectrum really using the media to portray individual judges in a light which does not comport with their views on what should be a just outcome of the case. That is not acceptable.
इसको थोड़ा सा आगे बढ़ाते हुए मैं आपसे पूछूंगा कि बहुत बार ऐसा होता है, एंड स्पेशली व्हेन वी आर टॉकिंग अबाउट सोशल मीडिया, जो जजेस हैं उनको क्रिटिसाइज किया जाता है फॉर देयर जजमेंट्स, फॉर in fact not for their judgments, but the judgments are not criticized, but the particular person is criticized that he is somebody this, he is somebody that. How should judges deal with it? Whether there is some kind of a training, or how do judges deal with this actually?
देखिए, आज हम सब एक सोशल मीडिया के युग में जी रहे हैं. सोशल मीडिया इज अ रियलिटी, सो देयर इज नो पॉइंट इन विशिंग इट अवे. अब ऐसी दुनिया में, ऐसे माहौल में हम कैसे अपना कार्य करें जजेस? एक तो ट्रेनिंग की बहुत ज़रूरत है जजेस के लिए, क्योंकि जब हम कॉलेज में पढ़ रहे थे, हम अपनी वकालत कर रहे थे, हम जजेस बन गए थे, we had no social media at that time. And there cannot be any denying the fact that social media, in that sense, really significantly affects the ability of judges to work and the kind of work which they do. Because, as you rightly said, the target is never the judgment, the target is the judge. Judges have no difficulty about, critique on what they write on the written word. But when it comes to targeting judges individually, then the target shifts from the outcome or the process of judging to individuals, which perhaps is the greatest danger to the independence of the judiciary. So, 25 or 30 years back, it was postulated that the state, the government, is a threat to the independence of the judiciary. Apart from judicial independence as a function of independence from the government, we have to also be careful that independence of the judiciary can be very seriously affected by these special interest groups which are constantly operating and trying to operate on the whole mind, on the environment in which judges decide cases. So it's important for judges to be cognizant of this. Judges को training देने की ज़रूरत है. The judicial academies have to be aware of these realities, the new realities, because this is not just a matter about criticizing the Supreme Court. The Supreme Court is in so many which ways, aloof from much that happens around. What about the district judges? What about the district judiciary? They don't have the kind of protection with the higher judiciary, the high courts, the Supreme Court have. And what is happening today affects the district judiciary as well. So it's important that we take adequate steps to train, to make the district judiciary aware of it, and to allow them to function fearlessly for the future.
I do want to come back to this almost unprecedented event that happened a few years ago, where 4 judges of the Supreme Court held a press conference and went against this master of the roster system, that the Chief Justice is the master of the roster. What have you done to change that? Because the view is that the Chief Justice has unbridled powers in deciding which bench gets cases and at what time they get it. For example, some of the cases that you have adjudicated upon, the Maharashtra case, for example, by the time the court took it up, or the Article 370 case, by the time the court took it up, the political reality on the ground had changed, and therefore, whatever the court opined, it didn't really matter to the political situation. How would you respond to that?
When you talk of the master of the roster and any critique of the master of the roster system, the first question you must ask yourself is, what is the alternative? Will all 34 judges sit down every morning and decide who will decide cases? Obviously not. I know of Supreme Courts, for instance, the Supreme Court in Nepal, where the judges every morning would take the entire body of cases which are coming up for. Therefore, the master of the roster system, which is basically this, that the Chief Justice allocates cases. But for your viewers, it's important to understand that individual cases are never picked out and allocated by the Chief Justice. The Chief Justice prepares a roster, and that roster is publicized. It's put out on the website. And what the roster basically does is this. If you take a particular branch, now the largest inflow of cases into the Supreme Court is criminal cases. Almost every judge of the Supreme Court is assigned criminal cases. Then you have more specialized areas like taxation. In taxation, you will have direct tax, you will have indirect tax. You have even more specialized branches of law like electricity law or securities law, competition law. But the roster which is prepared by the Chief Justice assigns cases on a subject-wise basis. We spoke about case categorization at the beginning of the interview. On the basis of this categorization, a roster is prepared and then that is publicized. Within that roster, cases are allocated on a random basis by the computer to different judges. So if there are 5 judges dealing with a particular subject matter, say service law, cases involving disputes on employment in public office in the state governments or the central government. So if there are 5 judges who are dealing with service cases, within those 5 judges, the allocation will be made on a random basis by the computer. Where the discretion of the Chief Justice arises is this. If a particular judge recuses from hearing a case on the ground that perhaps they know one of the parties or one of the parties is related to them, or that they have dealt with that case as a judge of the High Court. The case is then put up by the registry with a note before the Chief Justice that, well, Judge A has recused themselves, and would you now want to allocate the case to another bench? Which is what is done by the Chief Justice. Now, obviously, this is a human system, but to suggest that there are alternatives which are better, I would love to have any other alternative which is better than this. This has been time tested for 75 years, and it is something which has worked in our system. And it's very easy to criticize, my predecessors, for instance, and I've also encountered it, on the allocation of particular cases. But if you actually look at the statistics, you will find that the allocation is fair. Different judges within that roster allocation are assigned cases on an equitable basis.
I want to come back to something that Ananya asked about the collegium system, because there's been a lot of back and forth between the executive and the judiciary on whether the collegium system needs reform. And the point that the executive every time makes is that, look, judges are the only system we have where judges appoint themselves. The executive, ultimately the people decide, they vote whoever they want to vote for, and ultimately they become the executive. The legislature, again, the people decide. But it's only the judges who appoint other judges.
Well, there's a fundamental fallacy in this. Because as I explained a short while ago, the judges do not appoint the judges. The judges are part of a process of initiating the appointment of judges. But the entire process of appointment, let's take the case of appointment of the High Court judges, and then we'll deal with the Supreme Court judges. For appointment to the High Courts, the process of making the initial recommendation is initiated by a collegium consisting of the Chief Justice and the two senior-most judges of the High Court. Before they make their recommendations, they consult widely among the judges of the High Court who have seen the members of the bar. For the district judges who are appointed to the High Court, their records are evaluated. Their judgments are assessed by a judgments assessment committee outside the collegium. And it is on the basis of this holistic assessment that recommendation is made. But the recommendation does not necessarily result in that appointment being made. After the recommendation is made by the High Court Collegium, the recommendation goes to the state government, consisting primarily of the governor and the chief minister. The governor and the chief minister will decide on what their views on the proposed appointments are and send those views to the central government. One set of the recommendations comes to the Supreme Court. One set of the recommendations is sent to the Government of India in the Department of Justice or the Ministry of Law and Justice. The Government of India will process the file at different levels within the government, both at the level of the Intelligence Bureau and the general assessment of the government. All the inputs are put together by the Government of India and then sent to the Supreme Court of India. The file is then evaluated by the Supreme Court of India, and the Collegium of the Supreme Court will look at the entirety of the inputs on the file, including the inputs of the Government of India. Therefore, far from this being a sort of an incestuous process where judges appoint judges, it's a process which factors in the views of the judiciary as well as the views of the political executive. And why are the views of the judiciary important? The views of the judiciary is important for the simple reason that it is the judges who man the courts who see the quality of the bar which conducts cases before them. Obviously, the government, which is also an important stakeholder, does not hear lawyers on a day-to-day basis. They appoint lawyers to appear for the government, but they do not have an assessment of the generality of the bar. Therefore, you will see in a federal system like India, the very process of appointment is multi-layered. And in fact, one of the criticisms may be that it's so multi-layered so as to really not have a very time-bound solution. So the whole allegation or the whole criticism that judges appoint judges is entirely incorrect. Likewise, when it comes to the appointment of Supreme Court judges, it's not that, the Supreme Court Collegium just picks out a judge out of thin air. We look at the senior-most judges in the High Courts, including the Chief Justices. We look at their performance. We look at the judgments which they have delivered. We consult judges, particularly judges drawn from that particular High Court where that judge is serving for the present moment. Look at their views. It is then that those views are formulated and sent to the government. The government, if it does have a different take on a proposed appointment, will get back to the Collegium of the Supreme Court with their inputs. on the appointment. So this is in that sense a process which factors in both the views of the judiciary as well as the views of the government, particularly in the context of the High Court judges at different levels.
And if there is an objection from the government side or an objection from the collegium side, you don't think there is a need to make that objection public as to the people know why a particular judge has not been elevated? Or
Well, as you know, there have been times when we have made those objections public. We have put those objections in the public realm, and we have indicated while publishing our resolutions why those objections are not acceptable to us. But you must also understand that if we were to put every objection out in the public realm, say an objection which we have as the collegium, or an objection which the government has as the collegium, the government has as the political executive, there's a grave danger that good people will not accept judicial office, because people would not be willing to have every aspect of their personal lives or their professional lives scrutinized and put in the public realm. So in the name of transparency, do we really want to move to a system where good people, competent people, would just not be willing to accept judicial office? Even today, you find, particularly in the larger metropolitan cities like Delhi or Bombay, more and more young lawyers are not accepting judgeship at all. Now, if you put this kind of scrutiny about every aspect of their private lives into the public spectrum, people would, I dare say, would not want to accept judgeship at all, in which case you might be damaging the system more than benefiting it.
I do want to ask a related question, talking about scrutiny of judges, their personal assets and so on. I believe in the Supreme Court, out of the 34 judges, 27 have put their assets on the website, but on a voluntary basis. Why shouldn't the people of India know what is the personal assets of Supreme Court judges? I mean, politicians are expected to do that when they fight elections.
Now, the duty to disclose your assets is inflexible. Every judge of the Supreme Court has to put their assets in a statement before the Chief Justice. For the Chief Justice, the assets are filed with the Secretary General of the Supreme Court. And all the assets, all judges on their appointment to the Supreme Court have to file their statement of assets. So there is no exception to the norm that you have to file your statement of assets.
But the public should.
But second, the resolution of the Supreme Court, and that's not a resolution which we have adopted, that's a resolution which has been adopted in the past, whether the assets should be disclosed to the public at large is a matter for the individual judge to decide. In other words, the judge shall file their statement of assets. Whether they want this statement of assets to be put on the internet is again a matter for the individual choice of the judge. Every one of the judges, mind you, is tax audited. Every judge is subject to the same principles and laws which govern all of us as citizens. Now, there are two views on this. Do you want, for instance, to put everything that you have or you own, your wife's personal jewelry, your wedding ring, to be put out on the internet for people to just have some sense of curiosity about what you hold, and for there to be another round of trolling on that? That, I believe, is a matter of debate, and therefore, on a very considered view, the Supreme Court took the position earlier that while the duty to file assets is inflexible, whether you want your assets to be disclosed on the website is a matter for each individual judge to adopt. Because ultimately, as I said, every judge is subject to assessment of their returns and everything as any other citizen is.
There were a lot of talks, taking you back to the collegium a little, there were a lot of talks during your tenure that, there were some rifts between the collegium. How true are they, and how do you respond to all of them, many writing about that there were a rift between the collegium and the collegium meetings used to happen?
In India, there's a word called kite flying. And this is a perfect example of kite flying. But since you asked the question, I must tell you that, yes, judges have different perspectives, and that you see on the bench as well. None of us is similar in terms of our approach to law or our approach to life as any other individual. So when we decide cases as judges, it's this difference of perspective, not rifts as you call them, but differences of perspectives, which ultimately promotes a synthesis and an outcome which accords with justice. Likewise, when we discuss issues in the collegium, different judges bring the richness of their individual perspectives into the dialogue. It's a dialogical process. And we, all of us, respect each other's viewpoints. We factor in what all the other judges in the collegium say before we arrive at a synthesis. Speaking of whether there was a rift, there has been never a rift in the collegium of which I was a part after I became Chief Justice of India, even once. I don't think that we have had even a single rift in the collegium. We have always taken decisions with a great deal of sobriety, with maturity, understanding that we are all here for a limited period of time and we are entrusted with this enormous constitutional responsibility, conscious of the fact that sometimes a colleague may have a different perspective, but we never take decisions merely by a brute majority. We always factor in what another colleague has to say and try to bring about a sort of synthesis to ensure that the views of everyone are respected and taken to their logical conclusion.
So as I come to the concluding part, I mean, you said earlier a judge should be judged by his or her written word, but you've done a lot of things which are outside of the written word, whether it is live streaming of court proceedings, whether it is making the court building more disabled friendly, a whole bunch of things, which, you know, some people say are peripheral matters, but are important matters. What gives you most satisfaction about all of those things that you have done?
Now, you know, a judge has to be judged by their written word insofar as their work as a judge is concerned, right? But as a Chief Justice, your work, as I said, doesn't stop with what you write as a judge. You have to administer the system. And it's in the administration of the system that we took a lot of initiatives like live streaming. Yeah. Live streaming has promoted transparency in the process. I don't think it's peripheral at all. But for live streaming, our courts would have shut down during COVID. It was really the e-courts project and the live streaming that we did during COVID that actually ensured that we delivered justice at a time when there was a lockdown across the nation. Everything was closed, but not the courts. We were doing work every single day, even at the height of the lockdown. Now, therefore, that's really a case where we have used technology to ensure that we reach out to common citizens. And my perception has always been this, that the public has a very vital interest in the process of dispensing justice that goes on in the courts. And they are entitled to know how outcomes are arrived at, what is the level of dialogue which takes place in the court. Apart from live streaming, we have used technology in a very significant measure to reach out to citizens. There are 37,000 judgments of the Supreme Court since independence, all of which are written in English. Now, our citizens are not all conversant in English. We have been using machine-assisted AI translation to translate all these judgments of the Supreme Court into every Indian language which is recognized by the Constitution. So all the 37,000 judgments have been translated into Hindi. About 22,000 judgments have been translated into Punjabi. And this work is taking place across India. And what the consequence of this is that now the high courts as well are in the process of translating their judgments from English into the regional languages. The purpose of this is to ensure that the work which we do is actually comprehensible to common citizens. The average lawyer who argues in English in the Supreme Court may not be cognizant of the importance of this exercise which we are doing. The importance of that exercise is to ensure that we reach out to citizens. Third, we have digitized the entire repertoire of judgments of the Supreme Court. Until now, the judgments of the Supreme Court, until we promoted this project, which I'll shortly tell you about, all the judgments of the Supreme Court were actually being put out into the public realm by private publishers. They do a great job, I have no doubt about it. But that meant that lawyers and citizens who wanted access would have to pay for those private law reports. We have now digitized the entire repertoire of judgments. We call it the digital SCR, which is a free service which is provided to every citizen. So you can imagine law students coming from under-resourced law colleges in different parts of the country who would otherwise not have access to these private law reports can have free access to the judgments of the Supreme Court. So a lot of this work, of course, the ultimate satisfaction and fulfillment for a judge, including for a Chief Justice of India, is in the work which you do to resolve issues of common citizens which come before the court. But equally, there is a great amount of satisfaction in doing the kind of work which we are doing on the administrative side to make the Supreme Court an equal opportunity employer, an equal opportunity workspace. A large number of women are now coming into the workspace as young women lawyers. We have about 2,100 employees in the Supreme Court. About 50% of those employees are women. Now, we have a beautiful creche for young lawyers, both men and women, who bring their little children to court to ensure that nobody really falls by the wayside by just virtue of the fact that childbearing and child rearing is a very important responsibility which is assumed particularly by women in our society. So many of these initiatives which we have adopted, we have recently inaugurated the National Judicial Museum and Archives in the Supreme Court. The object of unveiling the National Judicial Museum and Archives is to again pitchfork the work and the life of the Indian judiciary into the broader societal canvas. And my vision has been this, that we must have more students from schools coming into the Supreme Court, young college students or just citizens coming there and looking at the museum. It tells you about ancient judicial history, medieval judicial history, colonial judicial history, the work of drafting the Constitution, including the role of the women in the Constituent Assembly, the work of the framers like Dr. B.R. Ambedkar and their contribution to the constitutional drafting process, the work of the Supreme Court post-independence. It's a high-tech electronic museum which we have created for the future, and I hope more and more citizens would benefit by that. So it would be really myopic to postulate that the work of the Supreme Court is only in terms of what happens between 10:30 in the morning and 4 in the evening. It's important to understand the wider institutional role of the Supreme Court in the life of the nation. And the work which I did as the Chief Justice of India, both as a judge and of course as the first amongst equals and on the administrative side, it was to sort of put this aspect of the life of the Supreme Court into the hearts of our citizens.
All right. A very, very interesting question. Since you've been the beacon of technology for the Supreme Court, you were the one who imagined a war room inside the Supreme Court. Do you feel with this advent of technology, the artificial intelligence, we would see an era in Indian judiciary or foreign judiciary for that matter, that we'll see AI replacing judges at some point?
Well, I don't think that's going to happen. I think that would be far-fetched. But equally, we cannot wish away AI. Obviously, we cannot wish away AI. As I said, that we are using machine learning to translate judgment. That's just the tip of the iceberg. AI is here to stay, evolve, and the important aspect of AI today is this, that AI today has, and increasingly in the future, would have the ability to think. AI would be a process having the ability not just to bring big data together and collate networks, but to create outcomes. Now, to what extent do we envision that AI should take over the process of judging? Speaking for myself, I may be among the older lot of more conservative judges on this aspect of the matter. I would be very reluctant to hand over the process of judging to a robot, because judging is not just about efficient outcomes. It's about empathetic outcomes. It's about compassion. It's about humanity. And I dare say that AI cannot make do for what human judging is all about. Human judges may have its elements of error. It may have its elements of, doing something which people don't think is right. Because after all, a human being is deciding the issue. But at the same time, I'd rather trust the human being as opposed to trusting a robot. But having said that, we have to embrace artificial intelligence. One area, for instance, where I've been exploring, and of course my term has ended, which we have been exploring, is the use of AI in getting cases ready for hearing, in categorization of cases. AI has the ability to read reams and reams of paper in split seconds. So the work which humans do, which may take probably weeks, can be done by an AI-assisted system in a matter of a few seconds or a minute. And therefore, there's a huge degree of potential for AI to transform the work which we are doing in the legal profession. And I'm sure that we can use the positives of AI while being cognizant of the intrinsic dangers of AI as well. For instance, racial profiling. AI can profile maybe on the basis of gender or sexuality or race. And these are some of the dangers of AI which have to be taken note of as well.
All right, Justice Chandrachud, for a long and successful innings as judge and then Chief Justice, and hopefully a long and peaceful post-retirement. Thank you very much for joining us.
Thank you very much. Thank you very much.
Thank you.
Thanks.